Okay, welcome to Chapter 4. Today we're going to be covering the criminal law. Um, Specifically, what we'll do is we will use your textbook as the core for this chapter, but I think in part because I have greater familiarity with it, and I think it makes it more relevant for you is the other major reason. We're going to take quite a bit of North Carolina criminal law and kind of intersperse it with the text. Now, you won't find that information in your text. You'll find it here in my PowerPoints. It won't show up on the regular weekly work. So this is really just for your edification, just to kind of help you understand a lot of these concepts and see how they're applied practically in North Carolina here. Okay, so learning objectives, talked about those before. A couple of questions to ask. Um, if you're going to talk about something, particularly a societal concept, I think it's fair to ask is, why do you have it? What is its function? Now, you could say that the criminal justice system is a function in and of itself. It's designed to promote whatever definition you feel of justice. But clearly, there are other social and economic reasons as to why you might have a criminal justice system. So, I think it's quite reasonable that as you're going through this chapter, you think about, okay, well, why do we do it this way? Or why do we have this? Or how come this crime is treated this way, or this crime is structured this way and not? And that, begs the question, is there a social, is there an economic functional law? And again, not just limited to these. You could ask, well, is there a religious function? Or any other major idea in the society? Um, why is it so important to prove intent? And that is basically motive. If people often will say, I only care about the facts. Well, a fact is, if you're talking about a homicide, a dead person is a dead person is a dead person. To the dead person, it can't possibly matter why they're dead. But it can matter to the living. So the question is, why are we concerned with the intent of someone who kills? And clearly we are. And a quick example here would be, clearly we're concerned if someone had taken another human life in self-defense. Their intent was to defend themselves. Clearly it's important if someone takes a human life by accident, recklessly, versus intentionally. So intent, which is a very subjective opinion, why did someone do something, has a big impact on the law. And I want, as you go through and think about concepts like insanity and infancy, diminished capacity, think about how intent is really shot through a lot of the, particularly the important felonies that we criminalize. How does one's appreciation of due process depend upon one's status, race, gender, or class in society? If you're concerned about due process, and we'll define due process later, basically the way something's done, does that change depending upon where you are? So for a quick example, if you owned hog farms, would you have a different idea about how people could sue you, or you could be sued because of the odor that came off them? I know that's civil, but what I'm trying to show you is you're in a different status than, say, someone going to Wake Tech. If you're just a college student, do you really care about hog farmers' rights? Where you are in the society, economically, socially, gender, race, class, all these things, impacts what kind of process you want. Okay, so let's talk a little bit about the development of the criminal law. The law in America traces its roots to what we call English common law. And this common law, as it's called, was developed in England, hence English common law, in the early Middle Ages, about 1100 AD, if you want an easy number. It really kind of started under Henry II. And it brought a lot of the concepts, or gave birth to a lot of the concepts that almost, more than 1,000 years later, we're still following. The modern sources of American criminal law, what we look at today most directly, constitutions, the U.S. Constitution, and to some extent the North Carolina Constitution, the written law or the statutes, the North Carolina General Statutes or the federal U.S. Code, regulations, those that are passed by administrative agencies, and case law. So the U.S. Constitution was written in the 1780s, more than 200 years ago now, and of course it applies everywhere that everywhere that is part of the United States. And we are particularly focused for the criminal law on the first 10 amendments of the Constitution, the so-called Bill of Rights. Now, the interesting thing about the Constitution is there's very little direct criminal law. There's no definition of murder in the federal Constitution. There's no definition of kidnapping. Most of the law in the federal Constitution is procedural law, like you have a right to a jury, or you have a right against cruel and unusual punishment. The North Carolina Constitution, which the current one that we have, is not our first. We've had several. Immediately after the Civil War, there was major changes in the 1860s. There was another constitution. Finally, we wound up with one in 1971. And I hate to say this, but many people in North Carolina don't read the North Carolina Constitution, don't pay too much attention to it. Again, though, like the federal Constitution, it really focuses on rights and procedures. There's very few direct criminal laws mentioned in the North Carolina Constitution. Most law, when people think about it, is this category, statutory law. This can be law that is passed by either the Congress of the United States, the House and the Senate of the United States, or the North Carolina State Legislature, the North Carolina State House and North Carolina State Senate. The federal law is passed by Congress, and the way that it's described is typically title and section. So you'll see it abbreviated as something like, the example I give here is 42 U.S.C. 1983. Now that means it is Title 42, kind of the broad grouping or categorization. United States Code, meaning it's federal statutory law, Section 1983. North Carolina, again, passed by the legislature. We use the term chapter, not title. So it's 14 North Carolina General Statutes, or sometimes you see GS, General Statutes, and then it gives a number like 1, 2, 3, all the way up to 461. Most North Carolina criminal law is found in Chapter 14 of the North Carolina General Statutes. There's a little bit in some of the, there's some up in 20. There's basically a few small pieces scattered around. Motor vehicle law, a little bit of environmental law, parks and recreation, if you will. But the bulk of it is in Chapter 14, certainly most of what we would be concerned with. And there is a link there, if you want, to the PDF of Chapter 14. Administrative law is something people don't think about a lot, but is in fact probably the most common law that's made today. These are rules or orders and decisions by federal or state agencies, administrative agencies, and they have the effect of law. We call it administrative law. What happens is that the Congress of the United States passes a enabling statute to create a administrative agency. Suppose you're going to create the IRS, the Internal Revenue Service. So Congress passes a law, says, okay, we're going to create the IRS. And we're going to give the IRS the power to make rules. So the IRS will be able to define what is and isn't income. You know, if I got a gift for my birthday, is that income? Do I have to report it? So they get to make law. They actually get to investigate. Hey, did someone not pay their taxes? The IRS can investigate that. And the IRS, believe it or not, actually runs its own courts if they find, yeah, you broke the law, you didn't report $1 million that you made. And we found that you didn't do it when we audited your taxes. That's the enforcement. You actually will not go directly to a federal court. You'll go to an IRS court. Because those, typically when you violate a statute from an administrative agency, those agencies have the expertise really to try those types of cases. North Carolina also has administrative agencies. Now, some violations of administrative law are civil, but some are criminal. You can go to jail. If you don't pay your taxes, you can go to jail. Case law. Any law that you make, I don't care what it is, can't cover all the possible circumstances in the universe. So if I say I'm going to make a law about self-defense, very often a scenario will arise, a series of events, where you can say, well, does self-defense apply here? Is it really valid? What happens is a judge will hear the case and say, okay, well, I think it does, or I think it doesn't. And he will apply what self-defense is. And whatever his decision is, let's suppose that we're arguing, if someone is coming at you with an open hand to slap you, you can't use deadly force to defend yourself. You can't shoot someone. So a judge hears a case where someone about to be slapped shoots another person. He makes a ruling that it is not self-defense. That individual is convicted. And we'll call that case Smith versus Jones. It goes up to the Supreme Court of North Carolina, Supreme Court of the United States. They go, yep, that trial judge is right. In the case of Smith versus Jones, we have established the precedent that an attack with an open hand is not sufficient provocation to use deadly force. So for the future then, every case that comes up where someone with an open hand went to slap somebody and the other person tried to shoot them or did shoot them, we know that that is not self-defense. We call the legal doctrine of precedent stare decisis, S-T-A-R-E-D-E-C-I-S-I-S, or let the decision stand. Now, sometimes you can break with precedent. Sometimes there's new or important reasons to change the law. So, an example of this, back in 1896, in the fairly famous case of Plessy versus Ferguson, a black man in the American South, in Louisiana specifically, tried to get on a railroad train, a car, get in. And he'd bought a first-class ticket, but they said, no, you have to sit back in that class where blacks sit. And he said, well, this isn't fair. I need to be treated equal. Went up to the Supreme Court of the United States in Plessy versus Ferguson, 1896. The Supreme Court of the United States ruled that you can have separate facilities for the races so long as they are equal. And this is where we get the term separate but equal. And therefore, for the next 60 years in the United States, for public accommodations, for hotels, for restaurants, for buses, for trains, for planes, you had separate facilities for blacks and separate facilities for whites. Now, of course, they were never equal. The first part was true. They were separate. The second part was never true. They were never equal. Finally, in 1954, in this is actually not the South, this is Kansas, Brown versus the Kansas City Board of Education, 1954, I believe it's the Warren Court. The Supreme Court heard this case where there were separate facilities for blacks and whites in the education system, and they said, this is inherently unequal. These are never equal. Therefore, we are abolishing the precedent that you can have separate but equal facilities. The application of the law violates the Constitution. You've got to integrate all public accommodations, schools, hotels, restaurants, whole 9 yards. Everything has got to be integrated. The precedent was overturned, and we establish a new precedent, no segregation. All right, the purposes of criminal law, the legal function. The law is supposed or proposed to operate as a way to protect citizens from criminal harm. Now, it will protect both individuals and the broader society. So, because sometimes it's not a physical harm, but a much more general harm. So, to take a crude example, if I wanted to hand out pictures of naked people in public, if I just wanted to give every passerby, I wanted to shove to their hands just like a petition, naked pictures. that would be illegal. That would be the dissemination of pornography. Okay? If you got one of those pictures, there's not a physical harm, but it's offensive to you. You shouldn't, if you're going to go shop at the Kroger or the Harris Teeter or the Piggly Wiggly, you shouldn't have to walk in front of someone that's distributing porn. So you can have a law that bans that. There's no physical harm there, but there could be moral or psychological harm. Very frequently, criminal law is created in response to a specific act. So you might have a horrific incident like a school shooting, and the legislature might pass a law that says, okay, like recently, maybe teachers should be armed, or maybe it should be illegal to bring guns on campus, whatever direction you want to go in. The social function. The law does reflect the morality of those who make the law. So you have to understand that the law has political, social, and economic interests involved. And sometimes there can be conflict between groups, different groups in society. We recently played out a debate between different groups in society about the legality, whether it would be legal to allow gay marriage. And there's nothing new on this. In the 1960s and 1970s, we had a very similar debate in the United States. Should we let blacks and whites get married? Remember that we're coming out of the age of separate but equal, and in many states it was against the law for blacks and whites to get married. And there was a conflict between the states that wanted to keep what was called the crime of miscegenation intact, not allowing blacks and whites to get married, and those that said, no, everyone should be able to, just like we had a conflict about gay marriage. Now, I want to be clear that you can construct an argument morally to not allow two men or two women to marry each other, or, to be fair about this, although I think it's a silly argument, you could construct a moral argument to not allow blacks and whites to marry. Just because I say it's a moral argument doesn't mean it's the correct moral argument, okay? So there was a conflict in society. It really revolved around definitions of marriage and societies, understanding of morality and religion. And this played out in the criminal law, where, of course, it was illegal to get married if you were of the same gender. And ultimately, that was overturned by the Supreme Court of the United States, where they said, no, we're going to allow gay marriage. We're seeing something similar to this has been going on for a long time, of a conflict between voting rights for racial minorities. Who should vote and when? How should people vote and when? So we make it a crime in some states, for example, for anybody who's ever been convicted of a felony to vote. In other states, like North Carolina, although we're having a little bit of wiffle waffle here, we say, well, after you're out of prison and you've served your sentence and paid off any fines, you can vote, or off probation. So, I mean, there can be social and political functions for the criminal law. All right, the elements of a crime. The first part, and we often say there's three parts to a crime. Those three parts quickly, and we'll go through each of them in just a second, are the physical act, the mental state of mind, and having both the physical act and the mental state of mind at the same time. So let's look at the first one, the physical act of crime. We use another Latin term here, actus reus. Crimes may typically are an action, an act of commission. You stab Fred, you burn down the church, you kidnap Mary. Sometimes they are acts of omission. You don't do something. You don't feed your children, for example. Sometimes they are even attempted acts. You try to kill someone. You try to rob a bank. So rarely are omissions crimes. There has to be an imposed order. We have to basically have something in the law that says you have to do this for your failure to do it to be a crime. Two quick examples. It's a crime not to feed your children. It's not a crime not to feed somebody else's children. If the neighbors across the street's kids are starving and they beg for food, but I don't give them food, it's not a crime. If my kids are starving and I don't feed them, and I could, it is a crime. Attempt is the act of taking a substantial step forward to committing a crime while having the ability and intent to do it. If you're just kidding around, like you say, oh, I'm going to rob a bank, as a joke, that's not a crime. But if you actually go out and you know, buy a gun and start drawing maps about the bank and case the bank, then we might have an attempt. Each element of the individual act is called, each part of it is called an element. So here are the examples of an element of an important crime. And you can find this crime in North Carolina General Statute, Chapter 14, Section 51. Okay, so we break up the act, and you see some of these are physical acts. Some of them go to intent, which I talked about at the beginning of this lecture. So you break, which literally means that you make a hole or an opening. And that can be as simple, you don't have to actually physically break a window. If you lifted the window up, if you turned the doorknob, you have broken. Now you notice that if I walked into a house that didn't have a door, so suppose a house is being built and they haven't put doors in yet, and I walked into the house, that would constitute the second thing. I have entered, but I did not break. Okay, so you break and you enter, third requirement. You can't have consent. If someone says, oh yeah, come on in, then it's not a burglary. Although you can't get that with trick, by the way. Dwelling house or sleeping apartment. So here we're limiting it to certain places. If you go into a store and rob it, it's not first degree burglary. Of another, can't be your own. Okay, another requirement. Well occupied. At night. These are two preconditions that if they don't exist, it's not going to be first degree burglary again. It might still be a crime, could be breaking and entering, could be a second degree burglary charge, could be, some other thing. The last one is with intent to commit any felony or larceny therein. So let's suppose it's a snowy night, you're freezing to death, you see a house, it's not your house, you break in to get warm. Now, you broke, you entered, you didn't have consent, it was dwelling house of another, it was occupied, it was night. You met everything, but you didn't break in to steal. You broke in to get warm. Not a burglary. Again, can be a crime, not a burglary. The second part really goes to what was your mental state when you did it. And we call this state your mens rea. It's the wrongful mental state, which is important and needed. You need it both, just like the physical act, you need to have this mental state. So what are some categories of mental states that can get you in trouble? Purposeful, knowingly, so you actually know what you're going to do when you do it. Negligently, you were just careless. Reckless, you were really careless. All of those can be the correct mental state to charge you with a crime. The degree of crime and intent. So you can see here as we look at this that if you've got first degree murder, typically that's a premeditated crime. Now the murder felony rule can be triggered, but you can see that in a first degree murder, the intent, what you were thinking when you did it, was very important because you really were going to do this thing. And if we go all the way down to involuntary manslaughter, maybe misdemeanor, you might not be thinking about it. You might be careless or reckless. So the person is dead in all 5 of these. But your intent when you acted is different. Therefore, the crime is different. Therefore, the penalty is different. There are some crimes that are strict liability crimes. We don't care what you were thinking. We only care, did you do the physical act? A lot of these are just defined under statute, and a lot of them are minor crimes. An example here is speeding. If you're doing 75 and a 55, but you didn't notice, right? You were just driving along. Maybe you were driving the speed to other people, so you had nothing to gauge it against. And the blue lights come on, and the cop pulls you over, and he says, did you know you were speeding? And you answer honestly, no, I don't. I didn't have any intent to speed. I just was following the other traffic. It's not a defense. You're still going to get a ticket. Still going to get convicted. Serious crimes, a little bit rare to have strict liability, although I've seen a tendency to have more of it. Example here would be statutory rape. If you have sex with someone and they are under a certain age, and it varies from state to state, but North Carolina is going to be 16 generally. If you have sex with someone under the age of 16, we don't care what your intent was. We don't care what you knew. Hey, they had a fake ID. I thought they were 18, or I thought they were 21, or I thought they could consent at this age. This person looked like an adult. None of those are defense. We simply ask, did you commit the physical act of having sex? Once the answer is yes, you're guilty of statutory rape. Accomplice liability is a little bit more complex, and if and when you take the course in North Carolina criminal law, you're going to really focus. Part of the first chapters we look at are all the accomplices. But basically, this means you help someone commit the crime. Now, it can be merely you conspired with them, you formed a plan. It can be that you aided or abetted. And this can be an assistance in any way if you do it knowingly. If you don't do it knowingly, if I go in and I'm working at a gun store and someone comes in and they say, I want to buy a gun. Okay, here you go. You got a pistol permit? Sure do. Here it is. Show it to me. Great. Here's your gun. I say, the gun, you go out and you stick up at a liquor store. If I didn't know you were walking out of that door to stick up the liquor store, I have no liability. On the other hand, if you come in and you say, hey, I want a gun that's going to be the best gun I can use to stick up a liquor store. I now know you're going to do this. If I go ahead and sell it to you, knowing you're going to use it, I could have liability. Even though it's legal to sell guns, it's not legal to conspire. So we do look at, are you an accessory before the fact, before the crime is committed? And you can be an accessory after the fact. So someone runs into your house and they said, hey, I just robbed the liquor store, can I hide here? And you say, sure. You're an accessory after the fact of the crime. Concurrence is, like I said, you have the physical act, you have the mental state. You have to have both of them at the same time, or what we call concurrence, in order to have a crime. All right, what can affect the level of charge? Well, different things can impact charge. Different things can decide how bad a crime is. We've talked a little bit already about intent. Did you intend to do something? But you could be motivated by hate or prejudice. That can make a crime worse. If I do something out of love, that's one crime. If I do something out of hate, that could be another. Quick example, that sounds crazy. Let me explain. If I love my child and he started to run into the street, and I said, oh my God, he's got to know not to do this again because he's going to be killed, and I spank him, right? I might spank him, and you might say, well, you're motivated by the love of the child. You're disciplining him for something that is in danger to him. That's not even a crime. But if I see a kid and I say, I just hate kids nowadays, and I grab that kid and I say, I hate kids, and I spank that kid. Now I'm motivated by hate. That is a crime. Now, sometimes we don't go to, is it a different crime? We just give you a different sentence. So this is called usually a penalty enhancement. The classic one in North Carolina is if you commit a robbery using a gun, so if you rob a liquor store or a bank, we add 5 years to your sentence. Another thing that affects a crime is how much harm is there? What damages flowed from it? So if it was incomplete, it's called an inchoate offense. Sometimes we call that an attempt. Was it merely just a conspiracy, but you never got to the point that you could rob it? So we do look at harm that flows out of it to affect the charge, or if there even is a charge. All right, now we're going to talk about some of the defenses to a criminal act. So we break these into two large categories: excuse and justification. If you can go and show to the satisfaction of the DA or the police that there is an excuse, there's not going to be a trial. If there is a justification, there's going to be a trial, but you're going to have to prove in court beyond a reasonable doubt. So let's look at them quickly as groupings. Excuse justifications. Here are two easy ones: infancy and juvenile status. Currently in North Carolina, if you are ages from the day you're born to your 6th birthday, okay, if you're younger than 6, you cannot be charged with any crime. Now, North Carolina, I read in the paper today, which is August 26, 2021, North Carolina today is trying to raise that to age 8. At first, the person introduced bills raised to age 10, But the DAs, the Association of District Attorneys, asked lawmakers not to raise it as high as 10, that 8 would be plenty high. So the North Carolina legislature, not wanting to run afoul of the North Carolina DAs, said sure. So right now we're debating whether to raise that to 8, but it is currently 6. Now, between the ages of 6 and 13 in North Carolina, you are always going to be treated as a juvenile. That means juvenile court, juvenile sentencing, juvenile rules. However, between the ages of 13, from your 12th birthday and your first day, okay, you may be treated as an adult in some cases. Classically, if you commit murder in North Carolina and you were 13 or 14, we could, in theory, charge you with murder as an adult. Insanity. Now, the thing about insanity is every state's going to have slightly different rules. The federal government's going to have slightly different rules. All states start with the presumption that you're sane, which means it's called an affirmative defense. You have to say, hey, wait a minute, I'm insane. Okay, you're insane. You have to prove that. Now, importantly, insanity is not a medical term. A doctor doesn't testify, hey, Tom Jones is insane. Mary Jane is insane. What the doctor testifies is that, or doctors, this person has this mental illness. Now, usually an insanity defense, to be worth its salt, a doctor will testify that someone is paranoid, schizophrenic. Conceivably, you could have some others, but it's pretty rare. So you show this, the other side, if it's clear, there usually won't be a trial. They'll say, okay, you're insane. You're going to be sent to a mental institution, and usually the time you're in the mental institution is as long, if not longer, than if you'd gone to prison. So North Carolina uses what's called the McNaughton rule, or something pretty close to it, and this developed, believe it or not, all the way back in 1843 when we knew a lot less about mental illness. But basically it says everyone's presumed to be sane, you've got to show insanity, and you've got to show a defect of reason from a disease of the mind. As I said, very rare, used in less than 1% of the cases. So if we had, say, 10,000 murders, we solve about 6,000 of them. We clear about 6,000, so it's about 60% or 6,000 murders. Let's just suppose that of those 6,000 murders, let's suppose about 4,000 went to trial. Because there's some that aren't going to go to trial. They're going to be cleared because the suspect's dead or they're already in jail. So you got 4,000 murders. 1% of them might raise the insanity defense. Okay, well, 1% of 4,000 is 40. And 25% of the time, when opposed, it's successful. So out of the 40 people in the United States in a given year that might raise insanity, 10 people in the whole United States would be able to use insanity successfully. So you can see it's pretty rare. Generally, it starts off with what's called a competency hearing, and then we look at the different tests, like the McNaughton, I didn't know what I was doing, the irresistible impulse, which could be, and I'm grossly simplifying these, I couldn't stop what I was doing, the ALI MPC test, which says I lack substantial capacity to appreciate what was wrong. And some states, there's a couple states that have simply abolished it. They've said, okay, if you're insane, you plead guilty but insane, and we'll handle you in the criminal court. Intoxication, there's two types of intoxication. There is voluntary and involuntary intoxication. If you voluntarily go out and get drunk, and a cop pulls you over because you are driving erratically and tries to charge you with a DUI, it is not a defense to say, hey, I was drunk. Yeah, no kidding, you were drunk. You're guilty of the crime. Now, involuntary is different. If someone was to place a substance in your food or your drink and it caused a problem, loss of muscle control or something, or intoxication, that would be a defense. Now, very rarely, unconsciousness or automatism caused by things like epilepsy, head trauma, fever, sleepwalking, sleep or forcible ingestion of drugs against your will is a defense, but it's pretty rare. Mistake, two different types of mistakes. Mistake of fact, mistake of law. If you make a reasonable mistake as to fact, oh, I saw a wallet, I picked it up, I have a black wallet, it looked like my wallet, I stuck it in my pocket, I walked away. Guy comes up and said, hey, you just stole my wallet, I put it down there for a second. You look at the wallet, it's his wallet. Well, that's a reasonable mistake. But you know, if you don't carry a wallet, and you see a wallet and you say, hey, I got a wallet like that at home when I was a kid, I bet you that's my wallet. You pick it up. That's a mistake, okay? It's not a good mistake. It's not a reasonable mistake. It's not going to be a defense. Now, a reasonable mistake can be a defense, but not, by the way, if it's an element of the crime. So for certain things, like going back to our statutory rape case, if you say, well, I made a mistake as the fact to her age, not a defense. Mistake of law. If you don't know what the law is and you break it, not a defense. Oh, I didn't know it was a law to trespass on this field. Well, what do you mean you didn't know? Well, I didn't see the sign. You don't have to. Under the North Carolina law, if a piece of property is posted in a manner, and the statute reads something like, a manner reasonably likely to come to the intention of someone entering. So it usually has to be posted at the entrance to the land. If you didn't go to the entrance, you climbed a stone wall 50 feet from where the entrance is, and you were walking on the land, and the land's posted. You can say, well, I made a mistake. Not a defense. Okay? Mistake of law, not a defense. Justification. Duress. I place a gun in the back of your head, and I say, give me the money in the cash register. You're faced with an immediate physical threat. That's a defense. It's a good defense. You can get out of the crime. Necessity. You can commit a minor crime to prevent greater harm. You can speed on the way to the hospital. Entrapment is a pretty rare one. You are induced to commit a crime by a public official when you wouldn't normally do it. Sometimes you see this when the police put an undercover agent or an undercover officer posing as a prostitute, and they get her to approach, usually her, get her to approach men and solicit. If she goes up and harasses someone until he agrees, that's entrapment. It's pretty rare. Self-defense is a big one. People talk a lot about this one. Self-defense, traditionally, you had a right to protect your body, the bodies of your loved ones, and your property. But that right was limited. For example, you could not use deadly force in defense of property. Put an asterisk there. There's some exceptions to that. Any force you use had to be proportional to the threat you face. So if I'm coming to slap you, you can't shoot me. And a big one, this is the one that's changed the most, you had a duty to retreat if you could do so safely. So someone's coming at you, and you could stand behind a door, lock it, and you'd be perfectly safe. You had a duty to do that as opposed to shooting that person, even if he represented a deadly threat to you. What's happened is North Carolina, like many states, and we see this in North Carolina General Statute 1451.2, that's Chapter 14, Section 51.2, and you can see NCGS abbreviated that way too, says that you can use deadly force to prevent imminent death or great bodily harm, and you do not have to retreat. Now, there was always, because remember I said there was a little asterisk, there was always no duty to retreat in your home. If you were in your own house, there is no duty for you to retreat from a threat. Never has been, North Carolina. All right. Substantive and procedural safeguards. So now we're going to look at some of the application of the criminal law. We're getting close here to the end, folks. Substantive law defines what's right and wrong. So substantive law defends what is murder, what is rape, what is arson, what is kidnapping. Procedural law says, okay, this is how we're going to have trials. This is how we're going to have someone arrested. This is how we're going to have someone charged. This is how we're going to have someone have if there is a need, a probable cause hearing. This is going to be our rules about bail. This is going to be our rules about having a trial and then having an appeal if necessary. All those things are procedural. They talk about what rights and duties you have and how it's enforced. Most procedural law starts with the Constitution, the Bill of Rights. So, to give you a quick example, you have a right to a jury because the Constitution of the United States says you have a right to a jury. Now, you can waive that right. We let you waive that right, but you have it. You have a right to remain silent, to not incriminate yourself. That's a Fifth Amendment right. But you can waive that right. You can talk to the police. So all the procedural law is designed to protect the rights of the individual. So here are some of the important ones. The Fourth Amendment. This is, and obviously there's things that are not criminal here I left off. For example, First Amendment is freedom of the press, freedom of speech. Second Amendment is right to bear arms. These are just some of the important ones in regards to the criminal law. The Fourth Amendment, this is your right against unreasonable search and seizure. So this is basically, they got to get a warrant to arrest you or search your house. Fifth Amendment, you can't be deprived of life, liberty, or property without due process. And this is also going to include things like your right against self-incrimination. We can't compel you to testify against yourself. Your Sixth Amendment, this is your right again you get a public trial, so we can't have them in secret. You get a speedy trial, whatever that means. We've had a lot of debate about that. You have a right to confront witnesses, so you can cross-examine them. You have a right to be represented by an attorney. Eighth Amendment, you can't have excessive bails, fines, and cruel, unusual punishments. None of these are allowed. Now, all these have to be defined, and that's going to be case law. That's going to be our friend precedent again. What is excessive? Well, if I give you a $1 million fine, for you, that's excessive. For Bill Gates, that's chump change. The 14th Amendment says due process exists, and the 14th Amendment says the federal due process rules, which had previously kind of only applied to when the federal government was doing something, now apply if the state government is doing something. Okay, both the 5th and the 14th Amendments provide a due process clause, and we do look at two types of due process. So you will hear substantive and procedural. Procedural is how the law is carried out. Substantive is the law by itself fair? It's easier to argue a violation of procedure than substantive, because when you argue substantive, you get into is the law really right or wrong? Quick example. Is the death penalty in the United States has never been ruled to be a violation of substantive due process. We've never said to kill someone, the state does it, that's wrong. But for a while, it goes back to two cases, Gregg v. Georgia and Furman v. Georgia. For a while in the 1970s, the Supreme Court of the United States said the way in which the death penalty was being applied was unconstitutional, so they made us change it. So the 5th and 14th Amendment, most of the time when it's being applied, applies on how the law acts, not is the law fair. You might not like the law against speeding. You might not like the law about gay marriage or the law about protests. But you're not going to win a substantive case about those. You may win a procedural case. If you say, okay, let me show you why the way the rules on protest of issuing permits or the ways on issuing marriage licenses are a violation of procedure. This group getting it and not that group getting it. These protests being allowed and that group not getting it. So it's easier to argue procedural due process violations. So we see a lot more procedural due process law. All right, a couple quick points and we're done here, right around our 45, 50 minutes. A little bit long, but try to avoid it. Very often the government will try to avoid due process because it's faster to get things done if you don't have to follow due process. And sometimes it's very hard to challenge. So for example, let's suppose the federal government right now decides you're a terrorist. Now they can't arrest you because they're going to have to follow the due process of, okay, here's the charge, here's the proof, here's the conviction, here's the sentence. But let's suppose they think you're a terrorist and they say, you know, we just don't want terrorists flying on planes, we're going to put you on the no-fly list. You are not allowed to fly on a U.S. commercial jet in the United States if the U.S. government puts you on the terrorist no-fly list. And let's suppose that your name is John Smith. And they've confused you with another John Smith. This other John Smith, yeah, he's a terrorist. He's in California, right? You live in North Carolina. But for whatever reason, you wind up on the list. Well, if there's procedural due process, you could challenge that. You could say, hey, you got the wrong guy. Let me prove it to you. You've got to take me off. But the courts have said no. The no-fly list is national security. There is no due process involved. If you're on it, you're on it, even if it's wrong. Also, final example, if you're not a U.S. citizen, sometimes even if you are a U.S. citizen, but if you are not a U.S. citizen, you can be held overseas by Americans without trial for years, even without any presentation of evidence. So let's suppose that you are living your life in whatever country you want, I don't care, Bolivia, and some people show up and they say, hey, you're a terrorist, we're going to turn you over to the Americans. And they grab you and they take you to an airport, and there's a couple guys from the CIA there, and they turn them over. The CIA flies you to Guantanamo, and they stick you in a cell, and they say you're a terrorist. You say, no, I'm not. Let me prove I'm not. No, you're not getting a trial. Now, you might think that's not possible, but in fact, that scenario is entirely possible. Of course, a lot of this goes to it's hard to prove who a terrorist is and isn't. So we've been operating for the last 20 years, since 9/11, that the accusation is enough. And there are people down in Guantanamo Bay, which is a U.S. military base in Cuba, that we've held for 20 years without trial. Are they terrorists? Yeah, they probably are. Can we prove it in a court of law? Maybe not. Should they get a trial? That's the basis of due process. All right, on that note, a little depressing, that'll end, and we'll pick up with Chapter 5 whenever you're ready.